Okay, well, I think most people are here. So hello and welcome to the February 2022 edition of Outline, DLA Piper's Planning Law Update. My name is Trevor Ivory. I'm the head of the UK planning team, and I'm joined today by some of my colleagues, Michael Greig, who joins us from Scotland to bring a Scottish law perspective to today's proceedings. Michael is a legal director in the team. Also by an associate in the team, Tobias Paul, who is back after a brief pause, but it feels like only yesterday, Tobias, you were here for the last time you were on. But we also have a new face who I'm delighted to introduce you to today. We have Sophie Stewart, who is new to the DLA planning team, or sort of nearly new perhaps, because she was with us before and moved on elsewhere. But I'm delighted to say Sophie has joined us as a new partner in the team with a particular focus on compulsory purchase and compensation work. So Sophie, really pleased to have you here today. And today we're having a bit of a smorgasbord really of different topics. We thought it was about time we just had a bit of a review of some of the recent cases that we haven't covered in the topic specific sessions of Outline that we've been doing recently. Some of the cases, they may be the ones you've missed, but all of them we think have a practical significance for those working in development and planning. So we're going to try and draw out some of those things that we think you need to take away from those cases. It's probably worth saying one case I'm not going to mention today is Hillside, a case that we talked about on the very first Outline back in December 2020, I think. The Hillside case at that point was a judgment of the Court of Appeal. It is a big case. It's causing all sorts of issues for many people across the planning system. It's the thing I think that I find myself advising on most. I'm just going to note that Hillside is still a problem and just point out that the Supreme Court has granted permission for the Court of Appeal's somewhat tricky decision to be reviewed by the Supreme Court. I understand that's likely to happen in the summer, probably around about early July. So with any luck, by the time we get to the autumn, we may have a judgment from the Supreme Court on Hillside, at which point we will no doubt be talking about it again, either celebrating if the Court of Appeal's decision is overturned or pondering what next if it turns out we've got to live with it forever. Just before we start, there is, as always, the Q&A function on your screens. Please do, if you have questions as we go along, please pop them in the Q&A box, and we will do our best to answer as many of them as we can as we go along. But without further ado, let's get on to our first couple of cases of the day, and we're going to start with some cases dealing with Scottish, with some Scottish issues around roads. And Michael, I'm going to come to you, if I may. Just sort of before we begin, can I just clarify terminology? Because of course, in England, we regularly talk about highways, but that's not a concept that extends up to Scotland, is it? So roads has quite a specific meaning in Scotland, whereas it doesn't so much down here.
Yeah, I think the thing is that what happened is we used to have lots and lots of different terms for, well, ways, to use a neutral term. We had streets, highways, and roads, and that was thought to be a little bit confusing. So in 1984, they basically did a consolidating piece of legislation, the Road Scotland Act 1984, that kind of brought all of the previous legislation together, did away with terms like highways and streets, and used the term road instead, which essentially is the same as a highway. It's a way over which there's a public right of passage. That's what it is. So it's essentially the same thing.
Yeah, good, thank you. So when we talk about roads in Scotland, effectively it's highway for
Effectively
those
it's
that are more
highways.
used to the English legal approach. Okay, well that's great. Let's start then with the Grange Trust cases. I thought was a good place to start.
Yeah.
And the cases have quite a long history. I think first considered by the Outer House of the Court of Session back in 2017. And if we probably need to start there, don't we, Michael? And it seems to me that there were two quite narrow points that were an issue at that point. And the first was in connection with the public list of roads, which is again sort of looking for the comparison with England. I think it's sort of what we might call the definitive map in England broadly, although I think it's a slightly different function, isn't it? But tell us about the public list of roads, and I think the question then that the court was looking at was, is that list of roads conclusive, wasn't it?
Yeah, I mean that's right. I mean, I think what's raised in the Grange trust cases is analogous to the position in England, which is why I thought it was interesting to talk about. By way of background, essentially this is about a strip of land to the side of a road in Comley Bank in Edinburgh, and to the side of the road there's a cricket club. And essentially there was a wall which separated the road, and the issue with a lot of these roads cases is about ownership and control of the strip of land over which the wall was built, because the people who purported to have ownership of it considered that it wasn't part of the road, and hence they could extract ransom value from a developer who wanted to take access over it. And I think that's a common theme on all roads and highway cases. A lot of them concern this issue about whether a developer has the access, the control that it needs over all the land to take access. So essentially that's what this was about. Now, what was slightly unusual about this case is that the list of public roads, and as you rightly say, there's a requirement for all local roads authorities in Scotland to pull together a list of all the roads which they are obliged to maintain, which again is analogous to the situation with highways authorities in England. And in this case, the list of public roads explicitly confirmed, well, one, that the road was publicly maintained, but also what it said was that the wall, which was the point at issue here, was explicitly said to be part of the adopted road. So that's a little unusual, because you don't normally have things like that in lists of public roads. But in this particular case, it made explicit reference to the wall. So that obviously gave the owners or purported owners of this particular strip of land a bit of a problem. So what they were trying to argue was that simply because the list of public roads referred to the wall being part of the road, that wasn't definitive. You need to look at the specific circumstances, and would allow them to argue that the wall wasn't part of the road, and hence they could still maintain their ransom situation. So as it turned out, the case was actually dismissed on the basis that these claimants didn't actually have title to sue, because what the court said is, well, because of the particular shenanigans that were going on in property terms, they needed to have the consent of the cricket club next door to the case, and they hadn't done that, so it was basically dismissed because they didn't have title to sue. But having said that, what the court then went on to do was to look at the merits of the arguments that had been before them, and in relation to this issue of the list of public roads, the court agreed with the petitioner that the list of public roads is not conclusive. Well, just because something is included within the list of public roads and it says that a particular part of a road is included, that's not conclusive. It was wrong in principle to hold that listing is conclusive, because there might be circumstances where it could be demonstrated that the Roads Authority had exceeded their powers in making the listing. And what the court was saying was that the purpose of including something within the list of public roads is not to define the limits of the maintenance responsibility, but really just to clarify which roads it was that the authority required to manage and maintain. So that was a fairly important finding, because obviously well, within Scotland anyway, there's quite a lot of variety in terms of how lists of public roads are put together. Some of them are just literally that, a list of the names of roads, but a lot of them are map based, and people will go and look at these maps and I think take some comfort from what's within a map-based local authority roads list. And I suppose what the court's clarifying here is you need to treat that with a precaution. You can't necessarily take for granted that just because a piece of land is said to be maintained as part of the road, that necessarily is the case. You need, essentially what you need to do is combine the map with your knowledge of the local area and figure out in the circumstances of the case whether in fact it does form part of the maintenance responsibility of the roads authority or not. So that's really the first part of the case.
That's point number one, and I think that for me that sort of is similar to the position in England, because although we call it the definitive map in England, the one thing you need to know about the definitive map is it's not definitive.
Well, exactly.
It's you have to treat it with caution, and I think that's an important warning, and with some real practical significances here, where there's a possible risk of a ransom if that boundary wall is not part of the road, doesn't have those public rights across it, then you've got a ransom situation. And that sort of moves us on to the second point, doesn't it? So okay, it's listed on the list of roads, the wall is noted, but that isn't necessarily conclusive. So the court then had to go on, didn't it? And I think was looking at the question of, well, actually, can a boundary wall be part of a road just as a matter of law? Is it possible for a wall to be part of a road? So where did they get to on that one?
Well, yeah, you're absolutely right. I think what the court said is that the normal position is that the horizontal extent of the road will normally run from boundary feature to boundary feature. Where there is a boundary feature, there's complications where there isn't, which I don't want to get into just now. But the wall wouldn't, such a wall would not normally be deemed to be part of the road. However, in the first instance decision, what the court said is that there might be arguments in this particular case that the wall served a retaining function, and it might also serve a function in terms of protecting traffic from activities on the cricket ground. I presume what they had in mind was, for example, cricket balls coming over and hitting cars going past, which probably is not very great. So during the first instance, the court was saying, well, generally speaking, walls would not be part of the road, but there might be circumstances where they could be. And what they then said is, well, if we hadn't dismissed this case because of lack of title, then we would have been holding a proof to determine whether or not the wall was part of the road. Then what we then had was a subsequent series of these leaf realm cases, because what seems to have happened is that the claimants realised they had a title problem in terms of being able to sue. So what they then did is transferred the title to a company, Leaf Rail Limited, who then basically started the litigation again and overcame the title problem, and were able to get past that to the next stage of the process. Unfortunately, they then entered another problem because the court did hold the proof, and what they then discovered is that the strip of issue, the strip of land over which the ball had been built, which the claimant was all excited about and thought they had ransom value, they decided it didn't actually exist in a property sense. Essentially, what this came down to is Leaf Firm were arguing that there was a gap in a title which had been acquired by the Roads Authority, and that because they were the successors of the body which had transferred that title to the council, the gap remained with them. And what the court said is, well, actually, when you look at it, and they spent a lot of time with the expert evidence in terms of what had been built where, they came to the view that the gap didn't exist at all. So there was no ransom strip. But again, helpfully, what the court did do is, because a lot of other additional evidence was then led on the function of the wall. They then set out conclusions on the issue of whether the wall was part of the road or not. What they then found was that well, essentially, there's quite a useful phrase that they said that what they said was the correct analysis when you're dealing with an issue about this is whether the contested structure, which in this case is a wall, was necessary in the sense of being functionally integral to the integrity of the road. So it's essentially what they were saying is the question of whether a boundary feature is included within the road or not depends on whether it serves a functional purpose with regard to the road in question. And here, they found that the court found that it did, because what they're saying is, one, it performed a retaining function, because what there was here was a 3-foot differential between ground levels. So what it did was it protected against subsidence of the road, but secondly also it protected road users from this vertical drop. So there was no doubt in the court's mind that in this case that wall was functionally integral to the road when it had been constructed, and was therefore part of the road for the purposes of the Roads Act. So I think, when you look at it as a whole, essentially the general position is that the horizontal extent of a road goes from building line to building line, fence line to fence line, wall line to wall line. But there can be circumstances, if you can show that a boundary feature, such as an embankment or a wall, is functionally integral to the road concerned, there can be circumstances in which that feature can also be part of the road. So I think that's the kind of, if you like, the takeaway from that.
Yeah. Great, thank you. And I think, Tobias, I'm going to come to you because I know this is a bit of a specialist subject of yours. Then Michael, I'm coming back to you for your last case. But sort of in both of those cases, ultimately the fact that the cases were decided on what are effectively property law matters. The roads points being sort of interesting, but actually not critical to the outcome of the case, because in each time they'd already lost before they got to the roads points. Now in England, we would say that that's therefore what lawyers would call obiter, and so not quite binding precedent in the way issues that go to the core reasons for the case being decided would be. So is that the same in Scotland? Or is there sort of a slight caveat as to the precedent value of these decisions?
I think the main point to bear in mind is that whilst the rules in Scotland versus England as to which judgment or opinion you follow if they're incompatible is slightly different, the general point is that what you do is you look for what is the actual reason or the ratio which led to the court reaching its final decision. And if there's anything else that the judges discuss, that's just talking around the subject, so it's not strictly speaking a binding precedent. However, in cases like this, given that it's come before the outer house of the Court of Session not once but twice now on the same facts, and that both judges, both Lady Wolfe and Lord Boyd, have sort of reached the same conclusions on the points, and that would be of very persuasive effect, even if it's not strictly binding.
Yeah, thank you. So similar to the approach I think we'd take in England and Wales. So Michael, back to you for the last case, and I'm just conscious of time, so I'm going to urge you to be brief on this one. But this is another case on roads. This one actually went to the inner house of the Court of Session, didn't it?
Yeah.
Last year, and this was looking at the extent of the road authority's duty to maintain the road, and in particular whether the duty to maintain the road extends to preventing damage to private property in the vicinity of the road. And it's the McCall's case that I'm talking about. So just if you could briefly just tell us what was going on and what do we take away from the McCall's case?
Yeah, well, this case concerned a bridge and with commercial premises and the arches of the bridge underneath. There was water egress from the bridge into the commercial premises. So essentially that's essentially what the concern was about. And the operators of the commercial property were arguing that the roads authority had a duty to take action to prevent the water egress as part of their statutory duty to maintain the road, and as part of that duty had to take into account impacts on neighbouring premises. So essentially what the court held was that the duty on the roads authority was simply to maintain the road in a proper state of repair for road users. There wasn't a corresponding duty in discharging that primary duty to have regard the impacts on somebody who was not a road user, they had power to consider such impacts, but not a duty to do so. The fundamental point here, which the court was getting to grips with, was the distinction between duties and powers. And in this case, what you had was a duty to maintain the road, and in this case, they had the duty to maintain the road surface, but they didn't have a maintenance responsibility as such for the bridge that underlay it. And I think this is quite an important point, which is, I suppose, why I'm raising this one, that roads authorities won't always have a maintenance maintenance duty in relation to the bridge. They will have powers to take maintenance action in relation to the bridge structure, but the duties to maintain the bridge will be on other people, primarily on the owners of the bridge, with the roads authority having power to require them to undertake that duty, alternatively to do the works themselves and to recover the costs from them. So that's essentially why I was raising it, was that it illustrates, whereas the previous case illustrated issues with horizontal extent of roads, this one's really bringing attention to the potential issues with vertical extent, that if a property owner or developer has got a bridge with a road over it in the vicinity of a development, then you need to be live to the point that there can be ongoing property-based maintenance responsibilities associated with that bridge. It can't be necessarily assumed that the roads authority is responsible. So that's, I suppose, the main takeaway from that one.
Thank you. And just sort of before we move on then from Scottish roads, we have been talking about Scottish roads. Do you think, Michael, there is any relevance to these cases outside of Scotland?
Well, yeah, I mean, I think in both cases, I think there is. I mean, the first one, I suppose, certainly as I understand it, the concepts of horizontal and vertical extent of roads and highways are quite similar. Certainly, you know, I've been using English cases in relation to vertical extent with relevance to Scotland, and I think the same concepts apply here. Obviously, when you look at the McCall's case, there are quite major differences in process, particularly in relation to adoption and maintenance of, well, particularly the adoption process and the construction process for roads, as opposed to the equivalent process in England. But nevertheless, certainly in terms of my understanding, you know, it's still going to be relevant in England to think about the vertical extent, because when a highway is dedicated and you enter into you know, into an agreement with the relevant highways authority to adopt it, I suppose the question will be, well, what's the extent of the maintenance responsibility which the highways authority is taking on? Is it taking on responsibility for maintenance of a bridge, for example? So I think the same fundamental issue applies whether you're north or south of the border. You just need to think where there's a bridge structure, who's responsible for that in terms of maintenance. That's the point.
Great, thank you. Well, that's the end of the road. Excuse
or the highway
for that topic. But we're going to move on to another. Actually, we're staying with some Scottish cases, although I think these have very definitely have relevance of, not just within Scotland but beyond, and they're dealing with the issue of consultation, and particularly what the consequences are for decisions when consultation's not been done properly. So Tobias, I'm going to come to you on these, please. And I think the first case is Graham's The Family Dairy case, which I know is close to your heart because you're a big fan of Graham's The Family Dairy. But putting that aside, and with enough of an advertisement for your preferred brand of milk, this was a challenge to a decision by the Scottish ministers to amend the Scottish planning policy document, which is broadly the sort of Scottish equivalent or partial equivalent to the English NPPF that we all know and some love. And specifically, they were looking to change the paragraphs dealing with my favourite topic, the presumption in favour of sustainable development and housing land supply. And I think we kind of have to step back before we get to the case, don't we, Tobias? And the reason that the Scottish ministers were looking to change the policy was as a result of an earlier case, a Gladman case, yet another Gladman case, which had been involving the interpretation of the existing presumption in favour and housing supply policies, and effectively the Scottish Government didn't like the interpretation of their own policies that the court told them that they had to apply in that Gladman case, didn't they?
That's exactly right, Trevor. I mean, at its most fundamental level, there'd been quite a lot of litigation about what you do and how you should approach a planning decision if a planning authority does not have the requisite housing land supply. But as far as this particular policy was concerned, it was concerned with what's sometimes referred to as the tilted balance, which is that, okay, you don't have sufficient housing land supply. What does that mean for how the decision maker, either the local planning authority or the reporter or inspector on appeal, should approach it? The Scottish Government's position was that it was, in effect, a two-step process. The first step, which was what they sort of had intended, they said, as the gatekeeper, is step one is you have to decide, is this proposal for sustainable development? And if it is, you then go on to apply the tilted balance, whereby if there's a housing land supply shortfall, then in order to refuse permission, you have to demonstrate that there are significant adverse impacts that outweigh that. Hence the tilted balance. It tilts the balancing exercise in favour of granting permission. What happened in the Gladman 2 case was that the Court of Session in effect said no, even if that's what you intended to adopt as your policy, that's not what you actually adopted as your policy. The judgment's relatively technical, but the main sort of gist of it is that the court said it's not a two-step process. If there is not the requisite housing land supply, then in determining whether it's sustainable development, you apply the tilted balance. So it merged everything into one, which the Scottish Government had certainly not intended.
I think what the court had done there was sort of they were drawing quite a lot of parallels with the presumption in favour in England and the tilted balance approach. And in fact, they say that in the case. But so the Scottish Government don't like the interpretation of their own policy that the court tells them they've got to have. So the beauty of being the Scottish Government is you can just rewrite your policy to make it say what you thought it said all along. And that was really where the consultation came in, and where we get to the Graham's Family Dairy case, because they consulted on some changes, some proposed changes to the policy in order to effectively put it back to what they had thought it was prior to the court telling them that they'd got it wrong in the first place, didn't they?
Yes, and there was the actual legal challenge. There were actually 3 different sets of petitioners, and they were all just sort of consolidated together. So there were actually 7 different legal grounds of challenge that the court had to deal with. The first one was very much about sort of whether the consultation that the Scottish ministers carried out on the proposed changes was legally adequate. And particularly whether the information provided as part of the consultation was so misleading as to render the entire consultation process unlawful. What had happened is that where the Scottish Government are proposing policy changes like this, they have to carry out what's called a regulatory impact assessment. The idea is that it's to identify, will this impose any additional burdens on individuals or businesses? What's the actual scope and magnitude of the change? How significant is it? In that impact assessment, which they prepared for this proposed change to the Scottish planning policy, they in effect said that there's no substantive change to the policy. This is just a sort of bit of technical redrafting, because the policy will mean what we always intended it to mean. So there's no sort of material difference there. The court was not impressed with that argument, shall we say.
I quite like the idea. Well, we always thought the policy said this. The court's told us that it doesn't say that, but we're just going to put it back to what we always thought. So therefore, there's been no change. I think this was slightly missing the point. And I did detect in the judgment there was the court sort of pointing out that maybe when they tell them that they tell someone they've got it wrong, that means something. And has some impact. But anyway, what was the court's decision on that first ground of challenge, the consultation point?
It's the only one that sort of we were discussing sort of binding precedents earlier. The court actually rejected 6 of the 7 grounds of challenge, so they're not sort of didn't go anywhere. The one ground the court upheld was on the adequacy of the consultation. And what's, I think, particularly interesting about it is that the court didn't sort of challenge any of the particular merits of the consultation itself or the proposed changes. But what they did say is this impact assessment gave a misleading impression as to actually the scale and effect of what the changes would be. It would affect a material change in the substance of the policy. It wasn't, the court didn't leave it there though. The actual sort of main concern which led to the ground of challenge being upheld was that the court then took it one step further, which is to say this impact assessment was misleading. It was published as part of the consultation. This was supposed to be a public consultation, but if you've got an impact assessment that says on this particular change, nothing in substance is changing, the court's concern was that a lot of people would read that and go, okay, I don't need to respond to this. And that is sort of the crux of the court's decision on the point, which is that it wasn't that people who responded to the consultation were disadvantaged. The Judge Lord Clark actually comments in his opinion that he didn't think the people who brought the case were disadvantaged because they actually responded to the consultation. It was actually about, in effect, unidentified third parties who, if the information had been correct and accurate, might have actually made a response which they didn't otherwise make, and that would have been new information which would have had to be taken into account.
Yeah, and I think it's a really key point, and I think it becomes more obvious why it's so important to everyone, because it's quite sort of specific in terms of a decision against the Scottish ministers. But I think as we come on to our next case, it becomes clear that idea that it was misleading to say that the consultation wasn't making a significant change. Therefore, some people may, without any evidence that anybody chose not to participate, but the court was concerned that there may have been people who may have decided not to participate in that consultation because of that misleading statement, and therefore they were prepared to quash the decision. So I think that kind of brings us into our next case. But just before we move on, I just, given my love of all things presumption in favour related, but Michael, just it seems to me, is this a sign of a sort of bit of a, as I read the case, I thought, is this a political move away from the presumption in favour of sustainable development and 5-year supply type issues in Scotland? And I'm particularly thinking one of the points that the Scottish ministers were doing was changing the way that 5-year housing requirement is calculated, effectively to exclude from that calculation undersupply in earlier years of the plan. Now that seems to me to be quite a fundamental shift away from the approach that's been taken both in England and Scotland over the last few years, at least, as to sort of trying to ramp up housing delivery by making sure that undersupply comes back to bite you in future years housing. Is there a bit of a political move away from that presumption in favour, tilted balance type approach going on north of the border?
Well, there very much is, because obviously the Scottish government was somewhat smarting from that decision, and they've now issued for consultation the new National Planning Framework 4, and that's very significant now because of other changes in the Scottish planning system. That means that the NPF going forward will actually form part of the development plan, along with LDPs. So essentially, planning applications will need to be made in accordance with that unless material considerations indicate otherwise. Now, as part of NPF 4, there's even more fundamental changes made to housing land beyond what we just discussed. So we now have 10-year housing land requirements which are set in the NPF, not set in local development plans. The requirement to maintain a 5-year effective housing land supply has been completely dumped. So we don't have that process anymore. And instead it will be replaced with a requirement for LDPs to provide what's called a deliverable housing land pipeline. But there won't be the 5-year effective housing land supply requirement. Instead, there's a different form of process, how that will work in practice. Personally, I don't find entirely clear. But yes, there very much is a political move away from 5-year housing land supply to something else.
We'll await Gladman 3.
We will await Gladman 3.
Just when you thought it was safe to go back in the water. Great. Well, let's come back to the consultation point. Sorry, I've taken us all off track there. But the other case, yet another Scottish case, actually, we've got a plethora. I'm not sure what the collective noun for a group of Scottish cases is, but we've got lots of them anyway. So this is the West End residents case, Tobias, and it wasn't. It seems to me it wasn't obviously a case about consultation. It was actually about a failure of the planning authority, Dundee, to require a design statement pursuant to Regulation 13 of the Scottish Development Management Procedure Regulations. But the court effectively concluded that yes, there had been a failure to require a design statement, and they should have required one, or should at least have applied their mind to the question of whether they ought to have required. So Dundee then went on to argue that, well, okay, we've had this failure, but nonetheless, all of the information that were in the design statement was in other documents that were in front of the planning authority. Therefore, there's not been a sort of an omission as a result of not having that document there. And so effectively they were saying, yes, there's a point, but the decision would inevitably have been the same anyway, because all the information that could have gone into a design statement was already before us. So therefore inviting the court not to quash the decision, but the court didn't agree with that, did it?
No, so the reason why sort of the design statement was potentially in play is that the proposal was actually for a bicycle docking station, like you have sort of in London or in Birmingham now, in the West Midlands. But it was located on a street in a conservation area right in front of a listed tenement building. And so in those circumstances, it may have been necessary for the design statement to be submitted, and it's fairly familiar document to people who work in the development field. It sets out sort of what's the design ethos, how have you considered the character of the surrounding area, what consultation have you carried out with sort of the local community and stakeholders, that sort of thing. The reason why the court didn't accept the council's argument that it wouldn't have made any difference is that if a design statement had been required by the planning authority and provided, it would have had to go on the statutory planning register, which there is a public right to inspect. And that would have happened during the consultation phase on the planning application. And in effect, so what the court said was that even though you addressed all of these heritage issues in the report of handling by the planning officer, this document, this information was not available to the public during the consultation phase of the application, and you ended up in the same position, and it's exactly the same reasoning as in the Graham's Family Dairy case, which is if the council had required that document and it had been put on the public register, that new information may have induced people who did not respond to have responded to the consultation, or if people did respond to the consultation, they may have told you something different. And because you didn't apply your mind's question as to whether that was a mandatory requirement for this particular application, then you have in effect denied the public the opportunity of meaningful informed consultation responses.
And that for me, I think that pulls those two cases together, and it's there that I think the relevance is for the wider development sector and those involved with planning applications more widely. It sort of suggests to me there is a trend here in these cases of saying, well, hold on, we're not going to let you off the hook if the failure has potentially impacted people's participation in a consultation process. If that's the case, then yes, all the information may have been exactly the same, so you may have come to the same conclusion, but what you don't know is whether someone would have participated in that consultation who didn't, and they may have brought something completely different to the decision that may have influenced the decision maker. And I think for me that's the takeaway, isn't it, Tobias, is you've got to make sure that the consultation exercises that you're involved with are right and proper, and they're covering everything they need to cover, and any even technical mistake in that process potentially leaves you vulnerable to a challenge. to any grant or planning permission or any other planning decision, I suppose. Sorry,
I think that's exactly correct, and I think that's why, whilst both of these cases we're actually dealing with some rather bespoke aspects specific to the Scottish planning system, nevertheless, the actual reasoning the courts in both cases applied, I think that's very much capable of more general application out with Scotland. And if you think about it, it actually just goes back to sort of the legal requirements and what is a public consultation for. You're supposed to do it when your proposal is at a formative stage, so that what the public and stakeholders tell you can have a meaningful impact on the final decision, and it's conscientiously taken into account. And I think when you look at it in that light, if that's what a consultation is supposed to do, I don't think it's surprising that the courts are reluctant to sort of accept arguments that consultation would not have made any difference to our final decision, because it does invite the question. So you're saying that no matter what anyone told you, you would never have made a different decision. That is in effect the argument which sort of the authority defending its decision is making in a case like this. And I think it's understandable why the courts, given the importance that is placed in law on effective consultation, I think it's understandable why the courts are reluctant to actually accept that type of argument. It's interesting as well that it's similar to the approach which the courts were taking in other cases on things like strategic environmental assessment and that sort of thing, where there are specific statutory requirements for public consultation. And it's, I think it's interesting that as the environmental law system has sort of become more embedded and we've got more case law on it, you can see some of those principles and the importance which the courts place on public participation and involvement actually sort of almost bleeding across into the general planning system. So I think there's a very clear direction of travel, I think.
Thank you. Right, so we've got about 15 minutes left. So it's time to bring in Sophie. Sophie, hello again.
Morning.
And we're going to talk PD rights, aren't we?
We are.
So and for our first case, we're going to go from Scotland to Wales. So we're moving around Great Britain a little bit now. So it's Magor and the Welsh ministers where I'd like to start, and it's a strange little case, it seems to me, and it's got quite a really tortured history. And I have to say, I'm amazed it went all the way to the Court of Appeal. And it was interesting to me, one of the judges, Sir Timothy Lloyd, he sort of did make the point of why on earth did Mr. Magor not just put in a planning application? It would have been so much easier than argue the toss on this quite discrete point. But I think there are some wider principles that come out of the point. But it was a narrow point by the time it got to the Court of Appeal. So that's probably the best place to start. What was the point?
You're quite right, Trevor. By the time we got to the Court of Appeal, bearing in mind at this point, Mr. Magor had actually successfully judicially reviewed an earlier decision, and we still ended up in further litigation. The very narrow point was essentially the correct interpretation of the meaning of the surface of the ground immediately adjacent to a building that needs to be measured for height for compliance with restrictions in the permitted development order, and specifically, even more so, whether the surface of the ground immediately adjacent could be out with the curtilage of the building proposed to be developed. However, what strikes me as quite interesting, and it is Timothy Lloyd again in lead judgment, is a number of times throughout his judgment, he actually refers to a ground of appeal that was prayed for, and leave to appeal on that ground was refused, which says to me actually he doesn't necessarily agree with the decision of the justices at first instance, because he is at pains to state that he can't make comment on it because it's not before him. And that's actually the question of whether, even before we look at in and out curtilage, what surface of the ground means, it's whether it's the level of the ground that should be taken at the point of application, or in circumstances where post practical completion there will be changes in as-built form land level, the height should be measured from what is proposed at completion. Now, the judge at first instance said the correct answer should be at completion, But as I say, he mentioned this more than one occasion, that he wasn't allowed to comment on it. So I suggest he doesn't agree with that. So if the point gets litigated again, we might actually find that getting reversed. But for the time being, we have to work on the basis that the assumption is it's a point of measurement post completion.
Yeah, I agree with you. He doesn't say it, but he hints, because he just keeps coming back to it. He can't get away from this point. And actually, it is. I think it's quite a surprising first instance judgment to say that when you're looking at a maximum height for a permitted development right, you take that maximum height from the finished level rather than the starting point. That seems to me. It does seem an odd decision, because you sort of think, well, actually, I can engineer whatever height I want at that point, because I've just got to keep piling it on. But interesting. And I suppose the other point, the actual point the Court of Appeal was looking at, was this question of what is immediately adjacent, because in the case, the building, it was a garden room, wasn't it, in the curtilage of his house. It was going to immediately abut the boundary wall. And effectively, the Court of Appeal said, well, the boundary wall isn't ground, because it's a wall, and therefore the immediately adjacent must be the land the other side of the wall, outside of the curtilage in the neighbour's garden, effectively, wasn't it? Which seemed to me such an obvious point, which is why I'm slightly perplexed as to how we ever got to the Court of Appeal on that. But it's relevant, isn't it? I think to a lot of PD rights, there is a height restriction.
Yes.
So that question of where do you measure height from, it can come up quite a bit, can't it?
Yes, and it's relevant in the sense that for the Welsh ministers, arguments were put forward in evidence that actually, in this case, the garden room, you're quite right, that Mr. McGaw's garden rose, and then he'd excavated, and he had leveled patios and steps, and it was quite a complicated, undulating site. Naturally, and as a result of material operations. But for the Welsh ministers, they were actually arguing there was a slight gap between the flank wall of the new garden room and the boundary wall, and that actually that could constitute the surface of ground adjacent, and they somehow suggested that somebody should sort of notionally wedge themselves up this tiny little thin piece of land, and take the measurement from there. And the court was quite clear that no, it can't be notional, it can't be deemed, it can't be built upon, which ostensibly this tiny little 10 centimetre gap's probably got some mortar that's coming out from the bottom of the new boundary wall that's been built. It has to be a sensible piece of unbuilt upon land when you take a purposive approach to why that height restriction is there, which is to protect views and amenity and limit scale and massing for the wider neighbourhood. So you can't just find this tiny point and go, right, we're going to have that. There has to be a lot more common sense put into it, which does mean it can be out of curtilage, which of itself leads on to some interesting points as well. If you're going to use that allowance in practice, which is that's fine on any given day. But if you are going out curtilage and it's in third-party ownership, what happens if your neighbour suddenly decides to come along with the digger and change their own land levels? It's quite a risky tactic, I think.
And the court said that, didn't they? They said, look, you okay, so you get the benefit of the fact your next door neighbour's land is higher than yours, so you get that benefit, but you only get that benefit if you get your thing built before your neighbour comes along and takes out the height difference, if they're that against the building that you're planning on putting up,
or indeed if they're doing something of their own. Yes,
yeah, true, very true. And that sort of that kind of takes us into our next case, which also takes us into the last part of Great Britain, at least, that we haven't visited today, which is we finally make it to England, and a High Court case, the CAB cab housing case, which came before one of my favourite judges, Mr. Justice Holgate, in the High Court. Always a good decision from Mr. Justice Holgate. And the facts here are quite complicated, and I don't think we need to get into them at all, do we? But effectively, the court was considering Class AA, which is the PD right allowing extra stories on residential. But again, I think it's much wider application to all of the PD rights that have a prior approval process, because it was how the prior approval process works was what Mr. Justice Holgate was looking at. And I think we can cut straight to the principles, because he quite handily, this very last paragraph, in that great clear way that Mr. Justice Holgate has, he just lists these are my points. So it's one of those cases where you don't have to read the case, you can just go straight to the last paragraph, read that, and you know everything that you need to know. But let's just look at some of those principles that came out, if we can, Sophie. I think the first one was about the extent to which scale can be controlled in a prior approval process. So you have your PD right, you have your sort of maximum heights and maximum parameters, and one of the issues was, well, okay, that's your maximum, but in that prior approval, is it possible to restrict to something below the maximum? What did the court have to say on that?
Yeah, and actually it's a thread that runs through not only scale, but other issues forming part of the prior approval process that the court was asked to look at as almost a preliminary issue. And that is whether the principle of development, so in this case, the principle of scale, is established in the PD right itself. And Holgate and others in agreement found that no, in the case of PDR that's subject to prior approval, the right to develop, essentially, the planning permission itself doesn't crystallize until approval is given. So it's in that context, I think, that I need to answer your question. And that's, you're quite right, the order itself establishes maximum parameters for scale, but actually within the prior approval process itself, it's then for the decision maker to determine anything under that maximum amount, whether it is appropriate in the given circumstances for that development. So very much, yes, scale can be controlled through the prior approval process, and it's a matter for planning judgment. And the court was, as it always is, at pains to point out that it's not going to interfere with a decision maker's judgment.
And I think it's quite an important point, isn't it? Because it does come up a lot, and I think we're probably all guilty at times of falling into the trap of saying, my PD right means I have a right. The clues in the title, so we sort of think I've got a right to build up to X height or whatever parameter we're dealing with, and actually it's a useful judgment reminding us that no, that's as far as you may be able to go under a PD right, but if in a particular circumstance it needs to be restricted, that very clearly, I think, comes out of the judgment. A decision maker can form that judgment and can restrict those parameters below the maximum.
Very much so.
Yeah.
I think that's interesting, Trevor, because it's almost sort of applying to the permitted development context something which is already a well-established principle from an outline planning permission, where you can have a grant for, say, up to 11,000 square meters of office space, but when you actually come to apply for reserved matters approval for the scale of the development, you're not necessarily guaranteed to get all of that.
Yeah, exactly, and the PD right is, as you say, is subject to the same exercise of discretion and judgment. So I think that's the big point in the case, but there are a couple of others that I'm just in the last 5 minutes, I'm going to squeeze in the others. Firstly, the court was looking at one of the criteria for the prior approval was in this case was impact on amenity. Mm-hmm. And the court looked at the interpretation of amenity, didn't it? And I think it was giving guidance on how we interpret amenity. Do we take a wide or a narrow interpretation of the phrase?
Yes, yeah, and there was some interesting arguments, I'm sure Tobias would have very much enjoyed, around canons of construction and lots of Latin phrases I'm not even going to attempt to A, remember, or B, pronounce correctly this morning. But yeah, it did boil down to essentially the meaning of including. So we have in the particular drafting of this part and others of the permitted development order, a wide term to start with, so effects on amenity, followed by including, and then a very specific list of amenity issues. And the court found that the use of the including was not intended to restrict in any way, shape or form the general and ordinary meaning of the word amenity, and the correct interpretation was that the specific points listed should be taken into account by the LPA, but that they in no way restricted anything else that fell within the ordinary meaning of the word amenity, such as noise or outlook, which weren't specifically included in the list. They, if they were relevant, should and could still be taken into consideration by the LPA as part of that prior approval. So it was given the widest meaning possible by the court. And in doing that, actually, it was quite interesting. And this actually links back to McGaw as well, insofar as interpretation of statutory instrument. There is a case going back to 1973 that actually looked at the permitted development order as it existed then, where a very similar approach to interpretation was taken. So we've now got a modern restatement that is still correct, despite the fact drafting styles have changed hugely in that intervening nearly 50 years, that where language is given no particular status, whether by definition or implication, that's the way it should be read.
We're going to run out of time to deal with all the principles, but I think there's one more that I think is relevant and worth flagging up, because it also, the decision has consequences for the consultation that you have to do as well, which is looking at the question of what an adjoining premise is for the purposes of assessing amenity of adjoining premises. And rather like where the immediately adjacent land was, the court took quite a flexible approach to what adjoining meant, didn't it?
It did, and it was quite clear that adjoining does not mean contiguous. Interestingly, here it did start looking at other parts of the order in terms of, so not only part class AA, but also looking at part 20, which is upwards extensions on mixed use commercial with residential over and purpose-built blocks of flats, where actually adjacent isn't used, but neighbouring is used instead. But they said when you read in context the order as a whole, quite clearly adjacent and neighbouring are interchangeable, and that it doesn't mean contiguous, because if you were to read it in that way, you would end up in a situation where you're defeating the purpose, particularly in relation to consultation, of how you need to assess impacts, because clearly they're not just going to potentially apply to immediate next door neighbours. And it has to be read in that way just to make it, to achieve its purpose, to make it make sense.
And that sort of very much does come back to those consultation cases we were just talking about. In that, if you have interpreted as a planning authority your duty to notify adjoining properties of a prior approval, if you've taken that to be the next door neighbour, then actually you haven't properly consulted, because you've got to go wider than that, which then brings in a whole judgment about how wide you go, of course. But that feels like a topic I'm not going to start with 1 minute left to go for the session.
Can I make two very, very quick points? And I'm very, very cognizant of the time we've got left. But the first, and it links back to McGaw, is that interestingly, Holgate did say, whilst adjacent and neighbouring and adjoining can be interchangeable, immediately adjoining means something else, but did not elucidate any further what he thought it meant. And the second point actually comes back to consultation again. And in evidence, both sides advanced the consultation documents that underpinned the order before it was brought into force to argue for their versions of interpretation. And Holgate made the point that the particular consultation in this case for the new classes of PDR did not include a draft instrument with it, and therefore limited weight was to be applied. However, where you have a consultation that does include a draft instrument, and the said instrument is materially made in the same form as the consultation, more weight can be added to what was said in that consultation document as to subsequent interpretation, which I think is an interesting point.
It is an interesting point. And a point we're going to have to leave hanging in the air, because we are now at time. So if I can just thank all of you for joining me today, also to thank our audience. As ever, we will upload this to the Outline YouTube channel. So if you've enjoyed it that much, you want to listen to it again, you'll be able to do that at your leisure. We'll be back next month for our next episode of Outline. We will be looking at first homes. Key deadline coming up for first homes at the end of March. So we'll be looking at first homes, reminding ourselves what the policy is, also looking at how that policy interplays with the development plan, and no doubt, if time allows, looking at some of the issues around how it's going to be captured in 106s and what those practical impacts are. So very much hope you can join us for the next episode of Outline, but in the meantime, thank you all very much and goodbye.